Hi guys, this is the second attempt at the guest lecture on NCLT and NCLAT. My name is Siva Raman Krishnan. I'm really sorry for uh, the session prematurely closing in the last one, but we'll get this right the second time. Okay, so like I said earlier, I'm an advocate practicing for about 6 years now, and I specialize mostly in corporate law, commercial laws, and arbitration. The Companies Act 2013 and the NCLT coming out in 2000, being notified in 2016 has been an exciting time for corporate lawyers. We uh, are at a threshold where you're either, there's a definitive change from what happened earlier under the Companies Act 1956 and what is happening now. And as a corporate lawyer, it is one of the most exciting times to be in the profession. Now, what has happened with the Companies Act 2013 and the NCLT coming into force? Basically, and that leads up to the topic of today's discussion, which is the convergence of corporate jurisdiction. Now, the CLB was just one of the many company law jurisdictions in India. There was the DRT, the Debt Recovery Tribunal. There was this SICA, the Sikh Industrial Companies Act, under which the BIFR and the AAIFR were constituted. Then, apart from that, you also had proceedings under SARFAESI. You had High Court exercising some jurisdiction. There was a plethora of jurisdiction where you could go for a same company could be dragged into multiple litigations in this for relatively the same transaction. Now, what this NCLT aims to do and the NCLAT aims to do is to unify all of these provisions into under one roof. That's the essential objective. Now, I know that this objective has not been met yet. It has not. Let's be clear. The NCLT being notified is not the end of the journey. It is just the beginning of the journey. Because the manner in which the NCLT has been notified, it requires serious legal discussions to go into to find out exactly which jurisdiction, what is your cause of action, which jurisdiction does it come into, where do you have to go, what kind of pleadings do you make, what kind of facts do you disclose. Now, the NCLT, when it came into force, it for now, as on date, in September 2016, it only substitutes the CLB. It does not do anything above what the CLB has already been doing, except for two differences. One, the CLB used to be in 5 jurisdictions, the NCLT is now in 11 jurisdictions. So accessibility is the biggest positive thing going for the NCLT. The second thing which the NCLT does slightly more differently than the CLB is the introduction of the class action suits. This concept, class action suits, was introduced in the Companies Act 2013. Now, I'm not going to go into full details of that because I would like to keep that for when we have a live discussion with our question answer. I would expect feedback and an interactive session on the class action suit and the insolvency code and etc. But for now, suffice it to say that the class action suit being introduced for the first time under the Companies Act 2013, the NCLT has been notified to preside over class action suits as well. It's a very interesting concept of class action suit, and it's being introduced in India for the first time. And now it finally has some teeth, that there is a proper forum which can adjudicate on. Apart from these two, the territorial jurisdiction and class action suit, the NCLT as on date does nothing different from what the CLB is already doing. The CLB used to, by and large, be responsible for oppression mismanagement. Almost 90% of the cases before the CLB were oppression mismanagement cases, which are now transferred to the NCLT and the NCLA. This is all cases post 1st June 2016. Cases prior to 1st June 2016 also stand transferred to NCLT as long as they are pending. If they are disposed of, there is a slight difference. Cases that were disposed of prior to 1st June 2016 now go before the High Court in appeal under Section 10F as per the old Act. Why is this anomaly there? Well, the Companies Act itself, Section 434, itself provides that cases disposed of by the CLB prior to the notification of NCLT will go back to the High Court. So the High Court is not gone out of the picture yet. The NCLT is there and the High Court's powers are still there. The High Court's powers are still retained in cases of winding up and in cases of amalgamation, mergers, and compromise arrangements. Now, these are provisions that are already there in the Companies Act 2013 and ideally should go to the tribunal. But because they have not yet been notified under the new Act, these provisions continue to exist under the old Act. The 1956 Act, as far as these provisions go, winding up, amalgamation, compromise, and arrangement, they have not yet been notified and they continue under the 1956 Act. So you still have the High Court exercising jurisdiction on these areas. Now let's go to the more interesting aspects, the BIFR and the AAIFR. Chapter 19 of the Companies Act 2013 essentially replaces the Sikh Industrial Companies Act, under which BIFR and AAIFR were constituted. Now, I would love to have a great discussion with you guys on what exactly the BIFR and the AAIFR does, and we'll keep that for a later date when it's a more interactive session. For now, let's just say that the BIFR is essentially a body which is created for rehabilitating Sikh companies. Now, when you say rehabilitation of Sikh companies, it is basically the group of the majority creditors from what you guys get in the insolvency code, the creditors committee. Something very similar to that is formed under the BIFR, under orders of the BIFR. The BIFR supervises. There's an authorized agent, operating agent, who's appointed by the BIFR, who's one of the majority creditors, and he takes over the management of the company and tries to rehabilitate it. Now, those provisions, although technically under the Companies Act and ideally should go to the tribunals, have not yet been notified. So the BIFR and the AIFR still continue to operate. Similarly, SARFAESI provisions, there is an interplay between the insolvency code and the SARFAESI provision, and for now, I mean, ideally everything should go to the NCLT, except for the insolvency code. Insolvency code deals with insolvency in two aspects. Individuals and firms, unlimited partnership firms, you still go back to the DRT, the Debt Recovery Tribunal. So the Debt Recovery Tribunal is one more area of jurisdiction which is preserved even after the NCLT is fully functional. Okay, so I know there's a lot to take in right now. I've discussed some 3-4 concepts and 4-5 jurisdictions at the same time, but this is what I was talking in the beginning of this video, that as a corporate lawyer, there is no better time to be in the profession right now, because the interplay is so vast and so complex that it requires a full day's research just to find out which jurisdiction you are going to go in front of. Ideally, in say a couple of years' time, when everything settles down and the NCLT is fully notified, you will essentially have 3 jurisdictions that deal with it. You'll have one, the NCLT, which takes care of everything corporate related. You will have the High Court, which will specifically deal with appeals from CLB orders passed before 1st June 2016. And you will have the DRT, which deals with insolvencies for individuals and unlimited partnership firms. Everything else, a residuary provision, it's akin to a residuary provision where the NCLT gets every other corporate matter, including reference to arbitrations, Section 9 applications, everything gets done. Section 9 under the Arbitration and Conciliation Act, which is interim measures under arbitration. As per the wordings of the Companies Act, everything gets transferred to the NCLT. Now, the NCLT, there are obviously pitfalls to the NCLT having such broad powers, and especially when it comes to bankruptcy and insolvency. Now, critics say that bankruptcy and insolvency is something which is very technical in nature, especially when you go to rehabilitation. When under the BIFR, what the BIFR is doing right now, they have a bench of technocrats. Those are people who have been in the industry, they know how businesses work, they know how companies work, and they understand accounts. A judge might not understand the accountings that go into rehabilitating a company. This is the biggest criticism that these tribunals face. And I would encourage all of you to go through those judgments of the Supreme Court where the NCLT formation itself was challenged. That is, the R. Gandhi versus Union of India versus R. Gandhi, and the Madras Bar Association versus Union of India. 10 judgment, and then again revived in 2013, and the decision finally passed in 2015. I can provide the citation for you, but I think this is pretty standard judgments, and then you should be able to easily access these. Now, the biggest criticism that the NCLT has faced is that they are essentially judicial members. At max, there will be like one judicial and one technical member, but they do not understand the accounts that go into the company. Now, what the Supreme Court said was that it doesn't matter for a tribunal to become suspect. Hope that's better. For the tribunal to exist and operate, it doesn't matter that the persons in charge of arriving at the decision are not well versed with the accounts and the financials of the company. As long as they can apply their judicial mind and judicial thinking to this process, it should be fine. Now, that's something which we will wait and see how it goes. But as of now, the NCLT having just been formulated, they're ideally doing the exact same functions of the CLB for now. The only difference being territorial jurisdiction. So now today, when we have earlier when we used to have cases in the CLB operation mismanagement in Chennai, which represented the whole of South India, now we have the option of Bangalore, Chennai, and Hyderabad. Now, obviously, the jurisdiction depends on the registered office of the company. Another criticism that stems from territorial jurisdiction is that companies have branches all over the country. Now, and this is more on the bankruptcy insolvency part, that the BIFR and AIFR are ideally, they're both situated in Delhi. So banks were mainly the creditors of these companies. They essentially have representatives in Delhi because all cases get streamlined and come to Delhi. Now with the formation of NCLT and the cases going everywhere, a branch of a company would have taken, so let's say there's one company based in Bangalore, registered office in Bangalore, but has branches in Kolkata, Delhi, Bombay, etc. Now each of these branches have taken some loans against the property against the office, the branch office. Now so there's a creditor in Calcutta, there's a creditor in Bombay, there's a creditor in Delhi, and there are obviously creditors in Bangalore. Now when the creditors want to file a bankruptcy petition or insolvency petition, and you want to approach the NCLT, you'll of course approach the NCLT in Bangalore. But now Bangalore NCLT has to pass orders which affect rights in Calcutta, Delhi, and Bombay. Not that it cannot be done; it can be done. Judicially, it is entirely possible, but logistically, it becomes a nightmare. The banks will have to cooperate, the state governments will have to cooperate, and the state itself will have to cooperate. Now, of course, these are issues that we will discuss in depth in our live session or maybe in a face-to-face session. But for now, I will just leave you with these small points to ponder on. The NCLT is essentially meant to converge jurisdiction of all corporate matters into one house. That is the sole objective of the NCLT. But in this phase-wise manner that we are dealing with in the NCLT, we should really ask ourselves, is it the best thing to do for companies at the moment? Now, there are obviously two views on this. I believe that as a lawyer, there is the fact that it is so nuanced and so complex is actually a challenge for lawyers. It's a challenge for young lawyers such as yourself who are going into the field of corporate law, because I can tell you from personal experience, every time we look at a case, a company law case, we have to first see whether the relevant section has been notified. If it's not been notified, then what are the provisions under the old act? And if it's been notified, what are the provisions under the new act? Now, once you do with that exercise, then we go into jurisdiction. Like I said, as of date, there is still no convergence of jurisdiction. There is still multiple jurisdictions all over the place, and there are notwithstanding clauses under some provision, like say for example the BIFR or the SICA has a notwithstanding clause that notwithstanding anything in any other act, the SICA will take precedence. So if there's a winding up petition and a BIFR petition against the same company, the rehabilitation petition takes precedence. But SARFAISI takes precedence over that. So there's an interplay of provisos to provisos to provisos, which create a sort of complex situation where companies themselves have to first spend spend a lot of effort and time just analyzing what is the jurisdiction. Now, NCLT as on date does not solve that problem. It is meant to. It is the ambition is that it will, and hopefully it will. But there are a lot of speed bumps on the way, and we will discuss all of this in our live session because I would love to have your interaction and your feedback when we do this. Okay? So look forward to chatting with all of you. I will thank the committee, and I'll hope that they set up a quick date in future.